worksheets to be archived and deleted in our calculator?
Certainly, this is Elaine Johnson, and I'll speak to that for the subcommittee. So we worked with the developers at the Judicial Council Administrative Office of the Courts in our Information Technology Division, and created a way to do this on those expired shared worksheets. It's a component that is probably less thought about than some of the other parts of the calculator, but we were easily able to replicate the process and being able to archive and delete a worksheet that was not shared, just one in your folder that you created. So we now have a process in place. We deployed that update November 10th. So if you do have worksheets that were shared with you and they have expired and they were just sitting in your folder, you can now go in and archive those worksheets and then in a separate process delete them. And so that's in place and seems to be working well. I've not had any complaints post deployments. I think we're good on that.
Now, Elaine, I know that first of all, I think that was deployed on November the 10th. If I have that correct, I know that there was something. Is there something on the website to tell practicing attorneys that feature is now available for them to tidy up their worksheets?
Well, we do have an information, an announcement section. However, it's not functioning all that well. It's not all that easy of an update. As a result of things like this, doing this type of update, one of the things that I've been talking with our developers about is changing the entire look and functionality of the home page of the calculator so that we can more readily put announcements of that nature further up on the page, just completely restructure the home page of the calculator so that those type of announcements can be seen. Right now, if I add anything, it's toward the bottom of the page and you have to scroll down to find it. So it's just not very user friendly. So there isn't anything that really tells users this information right now, but it's something that we're going to fix and update and make sure that it is more readily available so we can put those announcements there. And that's something we'll add when we have that new capability. So I don't have anything yet designed. I'll have to sit down with Latana as well, Noel as well, and work with the developers on any ideas they might have and anything that we can bring to the table to update the homepage of the calculator.
Also, in addition to that, Elaine, I have a good working relationship with the State Bar's Family Law section. They frequently, for something important enough, we will do an e-blast to the section.
Certainly.
We might want to come. We can do that, but also I'll be at the mid-year meeting of the Family Law section, and I can make an announcement there just to spread the word a little bit.
Let's do that. And let's send that e-blast out. Let's spread the word at the mid-year meeting, but also to the subcommittee members who may not know, I've announced this to the full commission at our last meeting. I actually have a new position since we last got together, and since I probably last talked to some of you. As of November 1st, I had been serving as Deputy Commissioner and General Counsel for the Department of Human Services. So that is DFACS, that is the Division of Child Support Services and the Division of Aging Services in terms of the legal team that works within the department. Anyway, that's my folks now. So I would maybe also just say that I will make sure that the DCSS folks in the AG's office gets the word about this. They may have the biggest volume of this and the biggest problem, frankly. So we'll try to get word out to the caseworkers through them, and I'll try to take some responsibility for that as well. And Deborah, did you have your hand raised here, or did we cover what you were needing to say about getting the word out?
I did, but when LaTonya brought up the idea of letting the bar know and getting an e-blast out through the bar, that was it. And I will also make a special effort to get the Georgia Legal Services and Atlanta Legal Aid folks on board, because they probably have nowhere near the volume that DCSS has, but still a combined significant volume. So I'll let them know.
Also, we'll add on GODR for the registered neutrals.
Perfect.
We'll have them. So I think
Perfect.
this will try to get as many folks as we can.
Well, to the extent that anyone's New Year's resolution is tidying up and better organizing their child support calculator worksheets, we will be able to assist in that greatly. So that's good. Good news. All right. Did any other members of the subcommittee have anything on that topic before we move on to the calculator maintenance update? This is a very exciting thing that Elaine has been exploring and staff has been exploring. So calculator maintenance, let's talk about this potential for a second version of the calculator specifically designed for self-represented litigants.
Yes, and this is Elaine again. I'll speak to this. I've had one very informal discussion with the supervisor who manages the developers. Again, Judicial Council, Administrative Office of the Courts, our IT department is where our developers are located. They do the coding and so forth, and the front end and the back end of the calculator, what it looks like and how it functions in the background. What we're doing on our end of it is design ideas. And we have to make sure that the calculator is doing only what the statute allows. So we're having to make sure that any functionality within the calculator follows the law. 19615. So we've had one very informal conversation, and then we met. Let's say I think it was in November, later November, and we began the process of really talking through what are some of the needs, and self-represented litigants was one of the areas that we thought if we can create another calculator online like the current one is, but specifically for self-represented litigants to make the process a little easier for them to create a worksheet. And so this is a really big design idea. It's, I might be simplifying it too much at the moment, but it's in such early stages that it's hard to give you anything definitive about what this will look like. It's just fortunately in working with this group of developers and the supervisor, Christy King, they have great ideas that they bring to the table. We have ideas, if they start taking us down a path that isn't consistent with the statute, we'll bring that back in to make sure that the calculator is only performing the functions the statute allows. Christy was telling me that after the first of the year, and she did not pin down if that's January or February, but she and I will talk again after the holidays. She would like to come before this subcommittee in the very near future, perhaps our next meeting, and talk with the group about some ideas and maybe actually show you something. But I haven't even seen anything yet at this point. It's in such early stages. But I like the idea of finding a way to help our self-represented litigants work through the calculation process more easily, where we're really guiding them through. They would have to know less information. But certainly all of this is in such early stages that it will require a lot of input. I know Deborah Johnson's been through this with us before. She's been at the table with us on several projects. Even the design of the current calculator that we have, you have to have a lot of meetings, a lot of interaction, with groups of people coming in from all walks of our legal system to ensure that we're thinking about all those individuals who use the calculator so that we are creating a product that really would work well for them. And so this is in such early stages. I can tell you that when we started developing the current calculator, it took us about 2 years to get that development finished. May still be the case. Maybe less time than that. I mean, it's difficult to pinpoint, but this is not something that we will take lightly or do very quickly, because we have to make sure that it is going to be a product that's useful to self-represented litigants, that we have to test it and test it and test it to make sure that anything we put in there functions correctly. So this is an idea that we've sort of tossed around just a little bit, and it's at the very early concept stage right now. But when we do have something to bring before you, for you to be the first group who, even sees any of it, we'll certainly put that on an agenda so that you can see it. And those are my comments on that topic.
Thank you, Elaine. And any discussion from the subcommittee members or questions for staff on that?
That self-represented litigant worksheet, it's just really meant to be just as user-friendly as possible for these individuals.
That would be the goal.
Have you looked at any? I practice in Florida as well, so there's a lot of self-help forms and things that exist on the Florida courts website for people who are doing those things. I can email some of that over, because they, for like financial affidavits and things like that, break down really well for pro ses what they need. If some of those instructions may be beneficial to the extent that we can tweak them to like a Georgia statute.
And I don't know, from the child support calculator perspective, a financial affidavit is not utilized within the calculator itself, but Regina or Noelle, maybe you have an answer to that.
It really meant it just for like an instructionary purpose, to giving those litigants like a way to say, I earned $12 an hour, put it in the thing.
I think we would need to have discussion. We've never had any kind of document of that nature. It's on the it's on another side of this process, but not within the calculator process, because we don't collect financial affidavit information within the calculation of child support. They have to input their income, which is obviously financial information, but a financial affidavit, we've never collected that for Georgia's child support calculator.
Right.
So
I'm not suggesting that that's what we need, but those kind of instructions may be beneficial for the purpose of a self-represented litigant, the way that they format those.
Yeah, and that sounds great. Yes, having it for that purpose, I completely agree. And it may be useful for, I know Deborah Johnson came from a world, she's retired recently, but she came from a world where she worked with a lot of self-represented litigants. And so I'm sure she would appreciate any guidance that helps us provide useful information. One of the things we do have on the Child Support Commission website under training is a module, 8 modules, that teaches a self-represented litigant how to navigate the calculator as it is today, with starting out with, well, how do you create your user account, and all the way to printing the worksheet when it finishes. So we do have some resources, but it's always a great idea to look at what other states are doing, see if there's anything that we can learn from that. Can we improve materials? This may be something the Georgia Bar would have an interest in. So Regina, what are your thoughts?
Well, I think Jackie, if you would send anything that has instructions like that related to child support, that you have easier access to and certain knowledge of, that would be helpful, because this dovetails actually into the discussion that we were having in the next agenda item in part, which is how to make instructions for the low income deviation, and how self-represented litigants might better, and maybe lawyers too, that might not do as much child support as the folks in this room, could better understand how to do a low income deviation. So all of this dovetails into, all these items dovetail into the discussions we're having about making all of this more user friendly and straightforward. to get from point A to point Z, as it were, in dealing with child support. So that would be helpful if you'll send that to staff and copy me for sure. Maybe also the other members just reply all to the last email they
Yeah.
sent, and we'll take a look at that. That'd be great.
Absolutely. I can
Sounds good.
I'll download those forms from the Florida courts and send them over. Sometimes they give a lot more instruction than we see on some of our stuff.
Yeah. No, I think we've got to do it with the number of pro se litigants is only increasing. So any other feedback on anything on that you about instructions, we'll sort of segue into the next topic, except to say, Elaine, if you could just let me know when you think the developers will be prepared to discuss and make a presentation, we will get them on the agenda, okay?
Absolutely, will do.
Anything else from anybody before we segue into the low-income deviation instructions?
Regina, I do have one thing to add, and it's just because I didn't have it in your notes here, but since I wrote those notes for you, I have gone ahead and prepared the update for Schedule B, not related to pre-existing orders, which is on the agenda further down, but related to the self-employment income on Schedule B, the first item for self-employment taxes paid. And I did the request last week in a help desk ticket for our developers to start making that update within the calculator so that we can deploy that in the first or second week of the new year so that we comply with the statute. I think it's in 19653. It's also in 19615, but we'll have an update for you at the next meeting on the date that deployment occurred.
So we will consider that an item of new business, and I appreciate that. I had a note about that. This is the time of year that happens every year as we go into a new tax year with calculations. So if you could just report on that at the next meeting and do that work, that would be great. That's the work good work that you do every year, and I'm glad to hear that it's on task and staff is. Who's surprised? On task, as always, about that. It does need to be updated.
Thank you.
So we'll make a little note about that. Anything else on calculator maintenance before we move to the low income deviation?
Not for me.
Okay, great. Well, since the last meeting, I sort of asked everybody to tell us if there were anything specific that you wanted to work on with staff yourself. Staff has continued to sort of look at generally these instructions for the low income deviation as we discussed. We're going to continue that work. And by we, that is the royal we, that is staff and me. And so, so any of you that are passionate about this, as we go through this, just let us know, and we will loop you in on all the work that we do trying to make the instructions in the calculator easier to understand, and in particular, easier for self-represented litigants to follow. Any discussion from staff on that? Anything further on that? Elaine, Noel?
No.
Any questions or comments from subcommittee members on that continuing task? All right, we're rocking and rolling on this. So that moves us to the pre-existing order calculations, old business. Again, this is a continuation of our lengthy discussion on August the 3rd about potentially changing instructions, simplifying instructions for the pre-existing order process. Any of you that want to work on that as that work progresses, you can let us know. But staff, do you have anything further on the pre-existing order calculations other than we're going to all continue to work on that?
Nothing further from me.
Any discussions, further discussions from the subcommittee to augment what we did in August, or what we talked about in August as we work through this? We'll certainly keep everybody in the loop as things progress.
Yes.
Anything from anybody on that?
I did, in the minutes, there was a discussion about just questions about how to do how to get people to swear to these, or swearing to the authenticity of those issues. This might be an oversimplification, but maybe it's as simple as now is having a verification at the end of all of these things, most of other pleadings that have to be submitted, just a verification at the end as to who submitted it, who prepared it. I mean, I know that we have that little button that we click at the bottom, prepared by plaintiff, prepared by defendant, but.
So that's an interesting point, because I think as I recall, when we started down this calculator path, e-signing was not much of a thing. E-signing is sort of a thing now, so perhaps it might be easier for there to be a verification in the worksheet now. Anybody else want to comment about that? Judge Bolden?
So I don't know that, as a practicing family lawyer, I would feel comfortable verifying a child support worksheet that I did, because a lot of times I don't have enough information about the other side's finances that I would feel comfortable swearing to that as a whole. And, I routinely will run 3 or 4 worksheets to say, if you find this, then it's this. If you find this, then it would be that. So I think it would need to be more specific. But I also think, as a general rule, attorneys who are trying very hard, I guess I would qualify it, would get a copy of the pre-existing order to include. And so moved outside of any kind of verification within the worksheet. And so maybe that would be something where, for self-represented litigants or attorneys that might need reminders, it would be helpful to point out that there needs to be that supporting documentation attached to the worksheet when it's submitted, or otherwise provided to the court. That was all.
I know, I agree with you on the, I do multiple scenarios for my worksheets. I agree with you on that point. Yeah.
Deborah, did you have, I think you got your hand raised.
Yes, sorry, I didn't unmute fast enough. I also do multiple worksheets and that kind of stuff. And I think it's routine that people do not know really what the other side has at the point when they're doing the worksheet. But I'm also concerned that in the low-income world, there are people who don't have income that's equal to or above the minimum wage full-time, and yet they're being told they must put on the worksheet that their income is $1262.50 a month because they don't have that much income. And so to have them swear to that strikes me as really a big problem. So I would much rather not see a verification of the child support worksheets. I like the idea of saying that people should attach a copy of the child support order if they're claiming a pre-existing order, although I will add that frequently people don't have a copy of the order. All they have is something from GCSS that maybe is some kind of letter, or maybe is something from the portal that tells them this is how much your child support is, and they're not able to get a copy of the actual order. They may even try asking some random person at the local GCSS office for the order, and they still can't get it. So I'd hate for that to be an absolute bar to them being able to assert that they're entitled to the pre-existing child support adjustment, but I really like the idea of saying that people should attach those orders.
So I think in terms of, just to reiterate what I was saying in August, or trying to articulate in August, it's the portion of the steps in the calculation where a judge is left to guess sometimes whether or not somebody's actually paying, which is the element of being able to claim the pre-existing order. And so the verification, and maybe this is just a matter of putting something in the instructions as well. I don't know, but I think that's the troubling piece, is that even when you've tracked down the order, even when somebody is found the order or uploaded the order, if we get to that stage of a process, there's still that piece where it may be less than clear that somebody's making a representation to the court that it's being paid. And so maybe that is an instructions piece along with the presentation of the pleadings. Maybe that's something to lift up to the statute review committee. I don't know, to make it clear in the statute that if you put that in the worksheet, that's a representation. I don't know.
Well, I would be happy to draft a sample verification that's just on that issue. Where I
That's
get
great.
worried is saying, I verify everything in this worksheet is true, and there's a lot of problems with that. But I will be happy to do a draft of a verification that's just on this issue of, yes, I'm paying such and such an amount toward this child support obligation that I have. And that might even be a way for somebody to say something useful about, I don't know the case number of the child support court case. All I know is the case number from GCSS, and here's what it is.
It might be helpful if it would be possible to do more than one like checkbox to say, so that you could say like, I verify that this is done and that there are no arrears, or I am in arrears X amount, or this is the other party's child support and I don't have any knowledge of whether or not it is paid or not paid. I mean, that's probably a more substantial update that would have to be made. But you know, if I find it in another case for the other side, like, I will add that into the worksheet, you know, unless I can see somehow that there were arrears or some other like child support recovery action against them.
So would people like me to draft something and then just send it around to this whole group, or just send it to staff for them to check it out first, or what?
I think sending it to this group would be a great place to start. I don't know what everybody else thinks about that, but in the meantime, I think if everybody else will also be thinking about those check boxes, Anna, those check boxes, let's walk through those steps and then agree on what those additional checks should be, and ask staff to get an estimate from the developers as to whether or not it can be done in the existing calculator. And let's sort of go from there.
Okay.
So let's work on both those things. Deborah's going to work on the verification, and Anna, if you've got time to work on the check boxes so that they're all circulating at the same time, we'll all check your work and have an opinion whether we've done the work or not.
I thought Ms. Bolden was suggesting things I should put in the affidavit or verification. Isn't that where
I think
we're gonna go?
I think she's suggesting, I don't want to speak for her too much, but I think what I heard was she is suggesting those check boxes be part of the calculator process before somebody can claim it, before it'll populate. They've got to reiterate what the statute requires. Am I misunderstanding what you're saying, Anna?
No, that was my suggestion, just because sometimes I'm entering that in, but I'm not comfortable verifying whether or not it's paid or not, because I'm doing it based on information I've been provided from the other side or from a pro se litigant on the other side. So
I'm concerned about the idea of adding more like things that people have to do exactly in a certain way before they can even assert that the pre-existing child support adjustment should apply, because it already is problematic requiring a case number and exact birth dates of children and exact names of children and other exact information that people don't have. If the person is not the one whose order it is, all they may know is, yeah, my soon-to-be ex has been paying child support for their first family, and I think it's about $200 a month, but they don't know all the details that are being required now, let alone more things before they can even assert that the pre-existing order exists and should be factored in.
But that person wouldn't be the one necessarily asking that the pre-existing order be recognized. They're just supplying information.
I've talked to people who do. They feel like, well, yeah, I know they're paying it, so that's only fair. So they're not trying to say, like lawyers would say, well, prove it. They're just like, they're trying to be honest and say, yeah, I know this is out there, but I don't know all the details.
But to get the deduction, it does have to be proven, and that's the whole point of this discussion. It is not appropriate for that deduction to take place for Georgia's children if it's not being paid by the non-custodial parent.
If the parties agree that yes, it's being paid, I know he pays it. It's coming out of his check every week because it was a source of, grumpiness in the family. I don't think that every family needs to be forced into an adversarial position where the adversary is the child support calculator, and they are agreeing that reality is what it is.
Well, this will be an interesting discussion to have,
Mm-hmm.
and debate to have, because I'll just opine that the opposite argument might be that the right to the child support belongs to the child, and not those two parents that might agree to who knows what. So, anyway, I do think that's it's a good debate to have. It's a good discussion to have, and it happens on all sorts of levels. About what role a judge has and what role the state has in calculating child support and many other things that relates to Georgia's families. So it's a good debate.
It is a good debate, and the statute does not require that people provide any particular type of proof. What the statute requires is these different elements, that there has to be an order, that the person has to be paying on the order, that they can't count the amount they're paying toward arrears, that the pre-existing order has to be further back in time, or its predecessor orders have to be further back in time than the support being currently set. Those are the requirements. It's not saying they have to be proven in any particular way, just like other statutes don't mandate exactly what evidence has to be presented to the court. And if the evidence presented to the court is somebody's sworn testimony saying, yeah, I pay this, or it's the parties' agreement that they are acknowledging that this is being paid, I think we might be overreaching if we start adding in particular elements of proof that are not mandated. But I agree, it's an interesting discussion, and we shouldn't have it now.
But I think you've hit the nail on the head, and that is that if it is a sworn, sort of back to the verification discussion, if it is sworn, then that's that part of the debate. And right now, it's not sworn.
No, but people testify in court all the time to what the story is, and that's frequently how things actually get decided.
Right. All right, well, we'll continue to work on that. Any other discussion about that pre-existing order calculation issue on Schedule B? Anybody have any new business other than our old business / new business, the upcoming update on the self-employment calculation? Any other new business to come before the subcommittee? All right, hearing none and seeing none, is there anything in the chat from anybody, Latona?
I have a couple of comments from
Let's just make sure I review those before we adjourn and talk about our next meeting. Keep going. Keep going. All right, very good. Well, we will circulate some dates for our next meeting. If anyone has any bad dates that you would like to avoid, meaning bad days of the week to avoid in the month of February, which is when we will likely meet again, unless there is something that comes to us directly from the commission that we would need to meet about before then. So look for something in February or early March. By then, the legislative session will be hopefully in full swing. I expect there will be many bills about child support. How many of them will get traction? Nobody knows until it starts happening. So looking forward to that. Anybody have anything else for the good of the order before we adjourn?
Regina, this is Elaine. I just wanted to let everyone know that February 24 is the date that we're looking at for the first statute review meeting in 2023. So we would not want to hold a technology calculator subcommittee meeting on that same day if we could avoid it. So if you'll scratch February 24 off your list, that would be helpful to staff in coordinating that one meeting for statute review. Thank you.
And thank you. And we'll also look at, after we talk to the developers about when they might be able to make this presentation, as we circulate these drafts of verifications and the other issues we've discussed, and try to do something that logically makes sense without just having a meeting for the sake of having a meeting. If it makes sense to have it after the statute review committee meets or after the next full commission meeting, we will do it that way, whether it's February or whether that's March. So just we'll be in touch about those dates. And if I don't talk to all of you or any of you before Christmas time, I hope everybody has a happy holiday season and a wonderful new year, and go dogs.
Go dogs.
All right, we'll see you next time.
Thanks, everyone.
Thanks, everybody.
Thank you.